Everyone, and welcome to the Santa Monica's 2022 Fair Housing Workshop. Thanks for joining us. My name is Andrea Kavanaugh, and I'm the Consumer Specialist with the Public Rights Division of the Santa Monica City Attorney's Office. I'd like to introduce my colleagues from the Public Rights Division that are here today. We have Chief Deputy City Attorney Etta Sa, Deputy City Attorneys Andrew Braver, Autumn Rindels, Gary Rhodes, and Jonathan Erwin-Frank, Investigator Bridget Garay, and Community Liaison Johanna Rodriguez. A quick note about our program today. It's being recorded. It will be available to watch later on the city's YouTube channel. Now I'd like to introduce Chief Deputy City Attorney Etta Sa, who will start off our program today. Take it away, Etta.
Thank you, Andrea. I think we're waiting for our slide.
I think it's coming. Etta, why don't you get started?
Okay, oh, of course. Thank you, Andrea. We are so happy that you can join us as we celebrate National Fair Housing Month here in Santa Monica. Starting in 2007, our office has put on a fair housing workshop every year. And every year it's a little different to reflect the changes that occur in our community, in the law, and changes in the city's programs and priorities. Certainly, we are not in the same place we were a year ago. There are federal, state, and local fair housing laws. It can be confusing. But Albert Einstein famously said, if you can't explain it simply, you don't understand it well enough. So I'd like to start today by asking three very simple questions. Number one, what is fair housing? Number two, how does fair housing impact our community? And number three, what do we do to further the city's commitment to fair housing? So the first question, what is fair housing? At its most basic level, fair housing is the idea that we have the right to choose and be housed free from unlawful discrimination. Housing discrimination can happen in many common situations, including when we look for an apartment to rent, when we look for a house to buy or try to get mortgage for the house. It can also happen when we buy insurance for our house or apartment. Unlawful housing discrimination generally starts with the framework of protected classes. Commonly known categories of protected classes include race, religion, national origin, gender, disability, and familial status. Fair housing protects people in the beginning, middle, and end of housing-related transactions. So on the front end, that's when you are looking to rent or buy. An example may be where a landlord showing a vacant unit sees that the person applying is a senior using a walker, and then says, oh, the vacant unit is on the second floor and it would not be a good fit for this person. The landlord never calls the person back and offers a unit to someone else. The middle stage, this would be discrimination during the tenancy. An example would be where a building manager reminds everyone that the building rules prohibit children from playing or making loud noises in common areas. The back end would be discrimination in the eviction process or the end of a lease. An example may be where a landlord decides to evict a tenant because the tenant is expecting a child or the tenant has a condition that requires a live-in caretaker. As these examples illustrate, fair housing laws protect all of us and impact us in our most mundane, routine parts of our lives. So question 2, how does fair housing affect our community? The Santa Monica community is made up of a diverse group of people, renters, homeowners, workers, business owners, visitors, and others. So many of us would like to live and work here. And how can you blame us? the weather, the beach, the pier, the restaurants and shops, and the natural beauty that many of us take for granted. But Santa Monica is limited geographically to approximately 8 square miles, bordered on one side by the Pacific Ocean. The city boundaries limit us, and there isn't enough housing stock for everyone who wants to live in the city. How do we ensure that the city welcomes diversity of people and backgrounds? Similarly, how do we ensure that vulnerable groups, people with disabilities, seniors on fixed incomes, people receiving public assistance, are not discriminated against and are not forced out? We can take a look at some of the steps the city has taken to protect housing for all. One example, the city's housing office runs the Preserve Our Diversity program. It provides cash-based assistance to eligible long-term rent control seniors to help pay rent. This preserves housing affordability and stability and helps our seniors age in place. Another example is the city's bold passage of an anti-discrimination housing law prohibiting source of income discrimination. In 2015, the city of Santa Monica was one of the first cities to expressly prohibit source of income discrimination in housing, adding source of income as a protected class, meaning landlords cannot refuse to rent based on public assistance recipient status or other source of income. After Santa Monica passed our local law, the state of California passed a similar law, and our very own Deputy City Attorney Gary Rhodes worked with the state to provide guidance and language. And after we successfully defended the city's source of income law in court, we have been using this law, enforcing it, working closely with legal aid and local housing authority to educate landlords about the law and to get them to agree to take Section 8 voucher holders. The source of income law is particularly relevant in this COVID-19 era and protects tenants who rely on the state's rental assistance funds for source of income discrimination. The end of March of this year, the statewide COVID-19 rental assistance program, commonly known as Housing is Key, stopped taking applications. By then, approximately 1,800 Santa Monica households were served with an average assistance of $15,000, and over $28 million in total funds was paid to Santa Monica tenants and landlords. Thanks to the state and local source of income laws, it is illegal for landlords to reject rental assistance funds. And in the last 2 years, our office has worked diligently with landlords to make sure that everyone understands and complies with the source of income law as it applies to COVID-19 rental assistance payments. Later this evening, you will hear more about the city's Right to Return program, one of the most recent programs the city has implemented to further the cause of fair housing. This brings us to our last question. What is our role in furthering the city's commitment to fair housing? The Public Rights Division prioritizes outreach. We work to inform the public about fair housing laws and available resources. A well-informed community is a healthy community, and we are here to help empower our members with knowledge. Today's workshop is but one example. And in fact, the Public Rights Division puts on workshops in Santa Monica and beyond. We are invited to speak on panels throughout the state of California. Since April of 2020, the Public Rights Division staff has presented or co-hosted housing rights events sponsored by Santa Monica Rent Control Board, the Legal Aid Foundation of Los Angeles, Western Center for Law and Poverty, Santa Monicans for Renters' Right, Fair Housing Council of San Diego, ACLU of Southern California, Wise and Healthy Aging, St. Joseph Center, and the Santa Monica Committee for Racial Justice. We also reached out to young folks through the Santa Monica schools and the annual Fair Housing Poster Contest. We actively work with community partners. The Housing Rights Center, we collaborate with them to investigate racial discrimination complaints and have training for our staff to become testers. We work with LawFla, the legal aid organization here in Santa Monica, to work out source of income Section 8 cases. We connect with disability support groups such as Disability Community Resource Center, DCRC. We bring outside guest speakers to attend so attendees can connect with landlord attorneys and representatives from housing agencies such as California Department of Fair Housing and Employment, DFEH. We provide public service messages. We create content on YouTube, City TV, and Facebook. We write newspaper columns about fair housing issues and cases. In addition to our outreach efforts, we can file lawsuits and take enforcement actions. As a government office, we have the authority to file enforcement actions on behalf of the public. We take complaints from individuals, we investigate, and in most cases, we are able to resolve the dispute without litigation before we ever have to go to court. But if we can't resolve it and there is sufficient evidence of a violation, we can and we have routinely filed lawsuits. Fair housing outreach, pioneering laws, and vigorous enforcement all help combat housing discrimination and protect the housing stability of our residents, especially our most vulnerable. On behalf of the city, the Public Rights Division of the City Attorney's Office continues with these efforts and commemorates Fair Housing Month. Thank you very much.
Thank you, Etta. That was a great presentation. We have a couple of more presentations for you today, and then we will take questions. Our panelists will take questions. So if you have questions for our panelists, please type them into the chat at any time during the workshop. And up next, I want to introduce Deputy City Attorney Gary Rhodes. He's going to talk about Santa Monica's Right to Return program and also its source of income anti-discrimination law. Go ahead, Gary, take it away. Thanks.
Okay, thanks, Andrea. Can you hear me okay?
Yes.
All right, great. All right, good evening, everybody, and happy Fair Housing Month. I'm going to have two presentations back to back, one on the source of income discrimination and protections against that discrimination that we have in Santa Monica and in California. And then I'll be talking about the Right to Return program that Etta mentioned that our city has just this year implemented. And source of income, you know, we've covered this in workshops in the past, but it keeps gaining in importance. Not only is it one of our, not only is source of income one of the most common protected classes in our complaints, but with the various rental assistance programs, especially those that are COVID related, COVID impact related, that this type of discrimination and protection from it is as important as ever. So we're going to go into some examples tonight of what to avoid if you are a housing provider, and then what to watch out for in terms of your rights if you are a tenant. Next slide, please. Etta went through the history of this law. The only thing I would add to what she said was that source of income discrimination has been banned in California for a couple of decades, but the traditional folks that were protected for almost 2 decades were based on things like Social Security, SSI, disability-related income, and public welfare. The courts did not allow tenants protection from rental subsidies under the state law. So in 2015, as Santa Monica was facing the continuing unfolding affordable housing crisis, you know, we had all these Section 8 vouchers, the Section 8 voucher program that we get from the feds that allows a low-income person to pay just 30 to no more than 40% of their rent each month, of their income for rent each month. Those vouchers were being turned away by enough local landlords to cause a problem of us losing some Section 8 voucher participants to other cities, or those voucher holders settling for substandard housing outside of the Section 8 program. So we passed that law, as Etta described, and then later the state passed a similar law that adds rental subsidies to the definition. So let's take a closer look at that. Next slide, please. As you see here, those amendments that I just discussed focus on just expanding the definition of source of income to include anyone who's got any kind of rental subsidy going on. The housing provider simply cannot say no to that person, or they can't say no to that person simply because they're relying on a rental subsidy. Next slide, please. Here are some examples of some of the programs that are in play here. Of course, Section 8, the voucher program I've discussed, that was the impetus for both amendments here in Santa Monica and on the statewide level. You have several other programs. I want to just draw attention to the next to last one because it's not discussed that much, but a lot of agencies, including nonprofits, get money from the state or the feds to help prevent homelessness. And sometimes that's just it's in the form of maybe 1 month's worth of help that a tenant needs to pay the rent. And those agencies like to pay the landlord directly to make sure that it goes for rent. And in the past, my office, I saw this happen several times. The landlord would say, no, I don't take rent from third parties. And that would cause the situation to escalate or deteriorate. And now they can't. Now the Section 8, or I'm sorry, these laws prohibit that. And then finally, the last one says any COVID relief fund assistance. As Etta mentioned, that's a huge thing this past couple of years. The COVID relief fund assistance comes with its own rules and laws, and those do much of the same work. In fact, right now it's very difficult for evictions to proceed if the courts can't see that every effort was made to get rental assistance lined up, especially if it's a non-payment of rent. I'm sorry, if it's a failure to pay rent type of case. Next slide, please. So does this mean that landlords are always required to accept Section 8? No, not always. The two exceptions, the big ones, would be if the rent that is advertised, the rent that the landlord is trying to get in good faith, doesn't pencil out with the Section 8 program. So in Santa Monica, for example, where we have a fair number of apartments that are renting for $4,000, that is not going to pencil out with the Section 8 program. We don't require landlords. The law does not require landlords to accept less rent than they would otherwise. And the target range right now, I would say, is around $3,000, anywhere from $2,500 to $3,000. That's something that can work out with Section 8. But when you get into $3,500 and $4,000, it probably will not pencil out. The other type of exception is, of course, if the tenant comes with a history, either bad credit or a criminal history, and the landlord already has established a protocol that says that they're not going to accept tenants with certain types of criminal history and certain types of bad rental history. The only caution I would give there is that you've got to be applying this to everybody equally, and then also Section 8 voucher holders in particular sometimes come with a lack of rental history. And so if a management company like the one we worked with last year had a policy where they would only accept tenants with quite a substantial amount of rental history, then that's a policy that's going to screen out Section 8 voucher holders as a practice. And that can be discrimination, that very type of policy. Next slide, please. Okay, so that was one example of a discriminatory practice right there. Now we're going to go through quite a few more. Let's go to the next slide. Advertising or stating a preference for tenants with certain sources of income. This is an example of what's now prohibited. The days of no Section 8, on yard signs in front of apartment buildings or in the rental website ads are long gone. The city of Alameda just had a case where the landlord's one mistake was publishing a no Section 8 ad. And that, by the way, had the effect of undermining everything the city of Alameda had been doing to let everybody know you can't do that. So that landlord ended up paying $6,000 for publishing that no Section 8 ad. Number two, of course, that's the big one. Landlords can no longer refuse an application from a prospective tenant simply because they're using a rental subsidy. They also can't charge a higher deposit or rent or treat the prospective tenant in any way differently just because they're using a voucher or some other subsidy. Refusing to enter into or renew a lease or using delay tactics. I want to emphasize the delay tactics because as some of you know that have worked with the Section 8 program and some of the other rental subsidy programs, both the landlord and the tenant have to fill out paperwork, and that paperwork has to be returned most commonly to the housing authority. So theoretically, a housing provider doesn't have to say no to the Section 8 applicant. They can just refuse to ever return the paperwork or refuse to return the paperwork for an existing tenant who finally, is finally going to be able to get a voucher to help them with their rent-burdened lives. And luckily, or fortunately for making this law something with teeth in it, this practice is also illegal. You can't try to run out the clock on a tenant's voucher. Next slide, please. By the way, I just want to say that we work with a lot of housing providers. Quite a few of our workshops in the past have been collaborative efforts with AGLA, and we often have landlord attorneys as speakers at this workshop. So what I've seen is that it's just a very small minority of owners who get onto fair housing thin ice. And what's great about these workshops and all the workshops that happen throughout the month, Fair Housing Month and in this country, is that landlords and property managers get to learn what their obligations are so that they don't get onto fair housing thin ice. So when I'm bringing up these examples, I realize it's just a minority of landlords who just don't know, or maybe they do, but usually don't know the law yet. One other, a few more practices here. Interrupting or terminating any tenancy because the tenant is using a housing voucher. This comes up when an existing tenant, often who's lived there for a long time, and their fixed income just no longer keeps up with the rent, and they're paying anywhere between 60 to 80% of their income every month for rent. And they finally get their voucher, and the landlord not only says no, but says it's time for you to go. That is illegal here and everywhere in California. Second one here on this slide, falsely representing that a unit is not available because the family will be using a housing voucher. Number 3, requiring any clause, condition, or restriction in the terms of rental agreement solely because the tenant will use a housing voucher. So one common thing is, and it's not common, I should say, one good example of this is restricting low-income tenants who are using vouchers from certain amenities such as the pool, the fitness center, the laundry room, under some, whack theory that these tenants are paying less, so they should get less. That is illegal under the fair housing rules. Next to last one, and this is one we've actually seen several times in Santa Monica. Landlords, understandably, have income requirements. They want to enter into a tenancy that is sustainable, and they want a tenant to show that they can continue to pay the rent month after month through the months and years. But when it comes to, for example, voucher holders, the voucher holder has been able to get this voucher because of their low income, and obviously a requirement that forces you to pay 2.5 to 3 times the amount of rent is not a logical policy when it comes to voucher holders. So if you're going to have an income requirement, the requirement needs to be based on the tenant's share of the rent, which again is, as I said, it's usually around 30% of the tenant's monthly income. And then finally, refusing repairs or improvements to the property because the family's using a housing voucher. And this can also be related to the very beginning of the tenancy where the landlord and the city schedule an inspection to make sure that we're not putting a voucher holder in an unsafe apartment. And if some repairs need to be made, then those repairs need to be made. Next slide, please. Okay, so just to wrap up on that topic, we're going to take questions at the end if you have any questions about source of income discrimination. And I'm going to proceed right into a presentation about the Right to Return program, a new one here in Santa Monica. So the new Right to Return program addresses historic zoning practices and land use decisions that disproportionately impacted low-income communities and communities of color and displaced thousands of households living in Santa Monica in the 1950s and 60s. Most of the slides you are about to see and the material and the research that I share this evening was collected and compiled by our amazing City Housing Division. And this presentation is actually a shorter one of the one that Mayor Pro Tem Kristen McCowan gave as a keynote speaker at the Fair Housing Month conference for HUD last week. Next slide, please. So to get things started with a summary of the program, the city has launched a pilot program that prioritizes placement on the city's affordable housing wait list for individuals or their descendants who can provide proof that they or their ancestors were displaced from Santa Monica during the 1950s and 1960s during certain major development projects of that time. To understand what happened here, right here in our own town during those 2 decades, it will help to look at what was happening nationally. So next slide, please. In the 1950s, citizen groups and local government programs began using code enforcement and rehabilitation to eliminate and stop the spread of so-called urban blight. The federal government provided funding for cities of all sizes to destroy what were called slum neighborhoods. Nationally, low-income households and communities of color bore the brunt of these so-called urban renewal programs. Through these programs and practices, cities across the country displaced hundreds of thousands of families from their homes and neighborhoods from 1950 to 1966. Now, please note that the end of that period is happening 2 years before the Fair Housing Act of 1968, also known as the Civil Rights Act of 1968, was passed. So we can only wonder what might have happened if that act was in place several years before, it might have stopped some of this negative impact. Here in Santa Monica, the local impact was significant in two areas of the city, the Belmar Triangle and the Pico Neighborhood. Next slide, please. First, the Belmar Triangle. From the late 1800s through the 1960s, millions of African Americans relocated from southern states, the North, Midwest, and West to both escape Jim Crow era segregationist policies and to increase their economic opportunity. African Americans also settled in Santa Monica, with the area around the Belmar Triangle serving as the town's first African American community. The city's African American population grew significantly during World War II as the labor shortage allowed large numbers of African Americans to find employment in local defense manufacturing. While we do not know the exact number of residents and businesses that made up the Belmar neighborhood, city directories show that there were 117 landowners occupying that 21-acre area that starts roughly around where the Civic Auditorium and courthouse is now and down to the beach. Next slide, please. The neighborhood, however, fell victim to the urban renewal that was taking place nationally. The land was taken by eminent domain to make way for the city's Civic Center and the Los Angeles Courthouse, both of which stand today. The houses and businesses that had comprised this vibrant community were bulldozed and or burned to the ground. And you see an example here in the picture, this house being burned down on July 1st, 1953. Next slide, please. The second neighborhood affected was the Pico neighborhood. In the late 1800s and early 1900s, California experienced a boom of railroad system construction. Laborers in LA County working on Southern and Pacific railroads, as well as the local Pacific Electric Railway, were made up of Chinese and Mexican immigrants. Many of these immigrant communities, along with African Americans, settled in Santa Monica's Pico neighborhood due to restrictive race-based covenants in other parts of Santa Monica. The Pico neighborhood was also more affordable to low-income and income working class residents, being made up of multiple apartment buildings and located in a manufacturing and industrial area. By the time the state of California used eminent domain to purchase houses and other property that now run the route of the I-10 freeway in order to connect downtown LA to the Pacific Coast Highway, the area was still made up of low-income communities, as well as Latino and African American households. The freeway expansion started in 1957 and was complete in 1966, again, just 2 years before the Fair Housing Act was passed. The project essentially split the Pico neighborhood in two. During this period, it is estimated that 600 Santa Monica households, making up about 1,500 people, lost their homes. Both the development of the Civic Center and I-10 expansion displaced thousands of Santa Monica residents. Some were able to locate to other parts of the city, while others permanently moved out of the area to other parts of LA and beyond, where they could find more affordable housing or could secure a home loan. By the late 1960s, it's estimated that well over 2,500 residents had been displaced in Santa Monica by the Civic Center and I-10 projects. Next slide, please. The city's effort to address all this incredible and tragic displacement from all those years ago involves amendments to its affordable housing guidelines that you see here. Those guidelines prioritize housing opportunities for Santa Monica residents and workers. Rather than providing a rental subsidy, the below market housing or BMH waitlist matches households to affordable apartments operated by for-profit and nonprofit owners at a rent that is lower than market rate. Households that meet the income eligibility requirements can apply for the BMH waitlist and are then contacted when apartment buildings have vacancies that fit their affordable rent and household composition needs. These give first priority to Santa Monicans who have been or will be displaced from their homes within 12 months due to a natural disaster, a government-ordered eviction, demolition of the building, an owner or relative occupancy of their apartment, or eviction due to the Ellis Act or a mobile home closure. We receive only a handful of these applicants annually. Second priority is given to income qualified persons who live or work in Santa Monica. All other households that do not qualify for these two priorities are placed on the wait list behind the prioritized households. So when we developed this policy, one of the big decisions, excuse me, was where to place this population that had been displaced along with their descendants in the context of this wait list. The city is taking great care to try to correct this past injustice, and we, of course, don't want to create another fair housing problem by giving a certain group of folks a preference. So to mitigate these concerns, we are operating this as a pilot program where applicants of historically displaced households are considered after households facing immediate displacement, but before applicants that live or work in Santa Monica. So you see, it's now the number 2 priority, and it's going to be capped at the first 100 applicants. We had an open call for applications for 30 days earlier this year, and we were pleasantly surprised that well over 100 people applied. And currently the staff is sifting through the applications, which include proof of displacement documents, such as rental agreements, deeds, immunization records, church records that include marriage certificates and baptismals, the stuff of life that all happened right here in Santa Monica many decades ago. And with that, I will end this and wait for your questions at the end.
Thank you so much, Gary. That was a great presentation. I do see some questions in the chat. Please do keep them coming. If you have questions for any of our panelists today, you can post your question in the chat and we'll address it at the end. Now I'd like to introduce Deputy City Attorneys Autumn Rindels and Jonathan Erwin-Frank. We're going to talk about reasonable accommodations and modifications. Take it away, Autumn and Jonathan. Thank you.
Thank you, Andrea. So Jonathan and I are going to talk to you a little bit about reasonable accommodations as they apply to housing. Next slide. And just to give you a brief outline of what we're going to go over, we're just generally going to talk about the scope of regulation and laws. There's federal laws, there's state laws, and there are local laws here in Santa Monica through our municipal code. But really, we'll get to the meat of things when we talk about what is a reasonable accommodation, and we'll go through that. And certainly, how does it work? How can a tenant request a reasonable accommodation, and sort of what is the obligation of a landlord or the obligation of a landlord or a housing provider? We'll go over sort of the general grounds for denial, and we will talk about the reasonable accommodation and eviction, what works, what can happen, what can't happen. And then lastly, we will be going through common tenant reasonable accommodations, giving you guys some sort of real world examples, and we'll go through some hypotheticals as well to round it out, to hopefully give you some really good understanding of what a reasonable accommodation is and how it is applied. Next slide. So the scope of regulations and laws, like I said, we have the federal, state, and local laws. And the good question is, who does this apply to? Really anyone and everyone. If you are an individual who is in rental housing, this applies to you. You certainly at any point can ask for a reasonable accommodation if you fall into and can provide the right requirements as required by law. And how do these different regulations sort of interplay with each other? Well, they really mirror each other. They're somewhat largely the same and related. However, California and Santa Monica's local municipal code is at times a little more strict than the federal laws. So if you're a landlord or a housing provider, it'd be a really good idea for you to go and read up on the differences between all of the laws, because they are all still applicable to you, and or ask the city. You could certainly give us a call, and we can't provide you legal advice, but we can try to provide you guidance. Or you can certainly ask your own attorney, housing attorney, and they would be able to give you some advice and guidance as well. Lastly, yes, as I've said multiple times now, Santa Monica does have a reasonable accommodation law that's specifically in our municipal code under 4.28.030G. What's neat about this law is it can be brought both by the city or by you as an individual if you are a tenant who thinks that a housing provider has violated reasonable accommodation laws. And that would happen if, say, you came to the city. Unfortunately, either we are unable to have the authority to take that case or your case to the next level, to a lawsuit. That doesn't leave you high and dry. You certainly can file your own lawsuit as well against your housing provider. Next slide. Okay, so what is a reasonable accommodation? And really, what is a reasonable accommodation is you're asking basically a landlord or housing provider for some type of change or exception to their general rules or policies or procedures due to a disability, and that this accommodation is necessary to provide an individual with the equal access to use or enjoy their housing opportunity. And there's two keywords here. One is disability, the other one is necessary. And when we're talking about a disability, we're talking about physical or mental impairments that would affect your ability to do some type of daily life activity, whether it be, for example, walking, working, sleeping, etc. And for it to be necessary, there has to be a link, or there has to be sort of there has to be a nexus between the disability that one might have and the accommodation that they are requesting. But something to note is that a tenant does not need to use the word reasonable accommodation for the duty of the landlord to kick in and go through the proper procedures to determine whether an accommodation or a reasonable accommodation should be granted. So you as a tenant, you don't have to say reasonable accommodation. It should be quite obvious what you're asking for the duty of the landlord to kick in. And landlords, you don't have to hear that. You're going to just have to be somewhat analytical, possibly at times, to determine that this is really what is happening. But you certainly can't deny someone's request just because they don't use those keywords. Next slide. Now, how does this all work? The request has to come in from someone. So first there has to be a request, there has to be a requester, and that person could be the actual individual that is needing that reasonable accommodation with the disability, or it could be someone authorized to act on their behalf. And now this second part is usually a parent. That would be a good example. They are asking for their child. There are other circumstances, though, where maybe an adult does not have the ability to communicate their reasonable accommodation request, and therefore, some third party might do that for them. The reasonable accommodation, it spans the entire tenancy, and actually even before the tenancy. It includes the application process through move out. The duty to provide a reasonable accommodation is ongoing. It never ends during this time period. And an example of what I mean through the move out, there are possibilities where a reasonable accommodation may be asked for additional time to move out due to someone's disability or someone's mental or physical disability. And something that is really important, and landlords and housing providers really need to keep it in mind, that this whole process, the request for an accommodation, any documentation or any evidence that is provided to you, especially medical records, they all are confidential, so you can't share that information. You can't talk about it with, your family. So all of this is confidential, and you should keep it, close to the vest and just keep it professional. Next slide. As a housing provider, if you are a housing provider, you can create forms and procedures for a tenant to request a reasonable accommodation from you. However, that is always helpful to do. Sometimes it creates a procedure and it makes it easy both on the landlord and on the tenant. However, you can't require those forms to be filled out in order to grant or even evaluate a reasonable accommodation. So certainly you can do that. You can create these forms and procedures, but they're not the end all. The forms and procedures can't ask or seek additional information that's not necessary for the evaluation of their request. And the forms and procedures themselves are subject to requests for reasonable accommodations. Say the way the form is written, someone may not be able to see it or understand it or fill it out, and therefore they may need a reasonable accommodation for that. Next slide. So what is the process that you use, both the tenant and the housing provider? What is the process that you use to evaluate a reasonable accommodation? It really is truly called the interactive process. There are going to be times, and it would be amazing if it happened all the time, but it doesn't. But sometimes a request can be immediately granted. Maybe it's something super easy, or the landlord just has everything in line and can accommodate immediately. Then you don't have to go through that interactive process because it's done. But if a request is not immediately available, or it can't be immediately granted, then the recipient, the landlord, the housing provider, must engage in a dialogue with the requester or the tenant to try to reach a resolution. And as a landlord or housing provider, it has to be timely. You can't sort of set this on the side of your desk and wait a few weeks or wait a few months. It has to be something that you deal with in a reasonable amount of time. And if for some reason, just right out of the gate, the tenant or the tenant or whoever is requesting that reasonable accommodation, they don't provide you with the proper evidence or proper paperwork for you to actually do a full evaluation, you can't just, it doesn't end there. You can't just deny them. It then sort of a duty falls on you as a housing provider or landlord to clarify or request that additional information. So you're going to need to do that. You're going to need, even though the requester is requesting it and they need to provide that information to you, you may have to kind of push them or ask them to provide additional information. Next slide. Now, again, if a reasonable accommodation is not immediately granted, and it would create an undue financial or administrative burden or cause some sort of fundamental alteration to the property. I'll talk a little bit more about this in reasons for denial. But if that comes up and there is some sort of conflict or hardship to the landlord or housing provider, the housing provider must suggest an alternative accommodation, and it must be equally effective. It has to essentially be an alternative that would put the tenant or the requester in the same position as they would have with the original accommodation request. So just because it creates a hardship doesn't mean that you get to immediately deny. You have to try and attempt to work out an alternative accommodation. Next slide. So briefly, grounds for denial, there are a number of different reasons, but these are the ones that are most often used or seen. You can deny as a landlord or housing provider the requester doesn't have if the requester doesn't have a disability, if they cannot provide you with the proper paperwork to prove that they have any disability at all, or how that disability may be affected by the reasonable accommodation. And that sort of goes into the second bullet point here, is that there's no link between the disability and the accommodation requested. An example could be that someone might have a mental disability, but they are asking for some sort of physical reasonable accommodation. Those two don't quite match up, and therefore a landlord or housing provider could deny that particular. One that is a little bit more confusing and would take a little bit more analysis is if there's a fundamental alteration of services or if there's a fundamental alteration of services or operations, that could possibly be a case-by-case ability to deny. But as a landlord, I would definitely seek legal advice before you deny and make sure that you're doing the proper analysis. Again, with undue financial and administrative burden, this is one can be very confusing as well. And if you think that you might fall into this category with a certain request as a landlord, I would definitely seek legal advice from a housing attorney to make sure that you aren't denying in violation of any reasonable accommodation laws. And lastly, one that we do see quite often is a direct threat to the health or safety of others, or substantial physical damage to the property of others. And certainly the risk cannot be mitigated by another reasonable accommodation. If there's just no other alternative out there and you've gone through the litany test of trying to find some reasonable accommodation, one just cannot be found, then that could be a ground for denial. And that ends my section, and I will turn it over to Jonathan now.
All right. Oh, can everyone see me here?
Yes.
Okay, great. So good evening. I'm going to touch on a.
Oh, I'm so sorry, Jonathan. I forgot there is a few more slides that I need to do. I completely
this
apologize.
might be the last one here, but.
Yes, I think there might be one or two. I apologize, everybody. I still have a few more things to say. So there were reasons for denying a reasonable accommodation, but there are a few things we need to talk about of how can you actually establish an accommodation is necessary. And this will be pertinent to both the tenant and the landlord. Again, landlords, as I already said, you may not seek information that is beyond what is necessary to evaluate the request. So specific diagnosis, medical records, those might be something that would be helpful, but not actually necessary for you to do a true evaluation. So you can't ask for additional information if the requester has already provided you reliable information about their disability and why that reasonable accommodation is necessary. Or the disability or necessity is already apparent. And that would happen is if, say, someone is in a wheelchair, the landlord or housing provider can see that there is a physical disability, or someone walks with a cane, or in certain circumstances, even maybe a mental disability would be something that is very obvious to the landlord. They don't need to provide anything more past that. And it does, and as I'm sort of giving you examples, the proof does not need to be from a medical provider. A lot of times I think it will be that way, but it doesn't have to be. It can be self-certification based upon someone sitting in a wheelchair, like I already said, or a reliable third party, say a parent can attest to a disability of a child, and it is something that a landlord could have constructive notice of because they've physically seen this disability. And so necessary doesn't automatically mean that there has to be extensive medical records or medical reports or even doctor's notes. Next slide.
All right, I think this is where I was going to pick up. So
yes. Sorry, this is now to Jonathan.
I'll jump right in. So I'm going to cover a few specific things, and we'll get into some examples as well. So I did want to start and just kind of reiterate the importance of privacy with respect to reasonable accommodation. And I did want to note the California regulations are very clear and explicit about this, that all information concerning an individual's disability accommodation request and medical verification have to be kept confidential unless there is a specific limited exception that's set forth in those regulations. And so related to that, a tenant only needs to provide sufficient information to be able to evaluate if that standard that Autumn has gone over has been met, the disability related need for an accommodation. And that could be done through a more general request in a supporting letter from a doctor or professional. Another thing that we like to emphasize is that a verifying letter from a doctor professional doesn't need to identify the exact syndrome or condition or even the severity of a tenant's disability, as long as it states that a tenant has a disability and that due to the nature of the disability, there's a disability-related need for the accommodation, then that's sufficient. We do see cases where the private information of the tenant might be shared with other tenants or landlords or other people. So it's always important to bear in mind the tenant's privacy and the legal requirements with respect to that. So the next thing that I wanted to cover and emphasize is with respect to reasonable accommodations and evictions. And I think this is not always intuitive for landlords, even tenants who may be accustomed to some of the rules where if you don't do something in time, for example, you get a 3-day notice to pay or quit and the tenant doesn't pay in that time period, you can't always remedy that and go back and undo the eviction or win the eviction, even if you're able to pay. So the first thing I want to say is that failure to give a reasonable accommodation is an affirmative defense in an eviction. Again, that's set out very clearly in the regulations. But also that a request for an accommodation can be made at any time during an eviction, including during or after trial. And the regulations that are set out in the California Reasonable Accommodation Law, they actually include very specific examples. And in those examples, they also include, a tenant asking as a reasonable accommodation that the eviction case be dismissed, and that a landlord would need to go through that interactive process and consider that along with whatever the reasonable accommodation request might be. So, for example, if a tenant is evicted because of damage to carpet and door frames, because of a wheelchair, and a landlord brings an eviction case for property damage or a lease violation, a landlord would need to consider a reasonable accommodation request to both, or in this case, a reasonable modification to widen the door frames and replace the floor, but also would need to consider a request to dismiss the unlawful detainer case. So we did want to go over some common reasonable accommodation and reasonable modification requests. And a reasonable modification is something we didn't get into a lot of detail about, but that is essentially when there is a request for a structural change. And the big difference there is that a tenant is required to cover the cost. And so these are things that we see that are quite common, where tenants make requests and a landlord needs to engage in that process, and if that standard is met, then granted accommodations. So parking is one that is very frequent, and maybe the most common would be to have a different parking space or have a parking space at all that's located near the residence, for all kinds of physical disabilities where it may be difficult to walk somewhere. But it could also be a type of space. For example, if a larger vehicle is needed, or transportation of equipment or breathing equipment or something where you need space on the side of the car to get in and out. Related to that, storage of equipment. It could be a special bed or walker, medical equipment. And that could be in the tenant's unit or even in a common area. transfer of units. A common example might be from a second or third floor to a first floor unit for someone with a physical disability. Could also be from a one bedroom unit to a two bedroom, and also to have a caretaker or a live-in caretaker that's required because of the disability. Alternative dates or methods of payment of rent. One example could be even if the lease gives a particular date for payment, a tenant could ask for an accommodation to be able to pay, after the date on which they receive their Social Security disability payment. Could even be more time to pay rent if the request for accommodation related to a disability, after receipt of a notice to pay rent or quit. Extensions of time, for example, if there's a settlement agreement to move out, but the tenant needs additional time to get their things out and request an accommodation, or to comply with other kinds of notices. And then there's service or emotional support animals, and I'm going to cover that in a little more detail. Okay, so we did want to cover assistance animals, especially because this might be one of the most common reasonable accommodation requests that a lot of landlords and tenants may be familiar with. So the first thing I wanted to go over is that there is a distinction in the law between service animals and support animals. And so a service animal is going to be an animal that is trained to perform specific tasks, including an animal that's in the process of training for people with disabilities. But it doesn't need to be a particular training or certification by the government or a nonprofit. And that's in contrast with an emotional support animal that may be providing, may be very important for someone who has a mental disability, which could even be severe anxiety or depression, but is not necessarily trained to perform specific tasks for someone with disabilities. Protections do apply to both. One important thing to note is that service animals should be permitted in all buildings that are covered by FEHA. And again, that's that state fair employment and housing law that includes the reasonable accommodation and modification. Whereas with respect to support animals, they may be required through this reasonable accommodation process, but a tenant should ask for reasonable accommodation if animals are otherwise prohibited. Now, with respect to service animals, there are some regulations, and those state that there are two permissible questions that a landlord could ask. The first being, are you an individual with a disability? And then what is the disability-related task that the animal has been trained to perform? They also say that one can't ask for a demonstration of whatever it is that the animal assists the disabled person with. Now, there are regulations with respect to support animal certifications. And although, just like most landlords in good faith try to comply with fair housing law, I think the same is true of tenants in good faith requesting reasonable accommodations for support animals. But nonetheless, we may have seen sort of form letter type situations. And so what this regulation says is a support animal certification from an online service that does not include an individual assessment from a medical professional is presumptively considered not reliable. And it has that definition of individualized, which essentially means that it at least considers and lays out the things that would meet those standards that Autumn went over for the particular case. But here again, it's important to note, and this was one of the things that Autumn mentioned as well, even if someone has a kind of online form letter, that should not be the end of the interactive process. If that might be considered unreliable, the landlord still needs to provide an opportunity to provide additional information before denying that request. I did want to go over some resources that are available in Santa Monica. So reasonable modification and home access program. And again, the modification request, that's those structural changes that may still be necessary for the person with a disability to enjoy their home in the same way that anyone else would. But nonetheless, because it's a major structural change, the law would require them to pay for that. The city of Santa Monica has partnered with DCRC to provide support and financial assistance to tenants who may be seeking reasonable modification. And so the program provides advice and may provide a stipend to eligible tenants who need modifications. I'd also take this opportunity to note that the DCRC has a financial assistance program for eligible tenants with a physical or mental disability who've encountered certain unexpected expenses, such as car repairs or medical bills or veterinary expenses. And if you would like more information about that or want to ask about your specific case, you can contact DCRC at that number that's listed there. All right, and I know Autumn already mentioned this, so I'll go over it very quickly. But I just wanted to note that we do have our city ordinance, anti-discrimination code that includes reasonable accommodation and reasonable modification. And so we will take inquiries and complaints, and if we go through the process that we do in all of these cases and determine that there's a violation or a reason for us to intervene, there are cases in which we'll do that. All right, so now we're going to go over several just sort of hypothetical situations to give a little bit more of a flavor of what these might look like. So I think Autumn was going to read this if she's still
I'm still here.
Great. And then I will go over the response.
Yosef is an individual with a disability who has a Great Dane dog trained to perform tasks for persons with disabilities. Yosef does not tell his landlord about the dog, and his landlord brings an eviction action for violation of the no pets policy in the lease. During the eviction trial, Yosef requests an accommodation that the eviction case be dismissed and that he be allowed to have his dog in his apartment. What must the landlord do?
All right. So the answer, I think, as in most cases, the landlord has to consider the request and engage in the interactive process. And I wanted to include this to emphasize again that that's even though the eviction trial is ongoing, and even though he may have been given a notice of lease violation and perhaps even to cure, the landlord is still going to have to consider that reasonable accommodation request, even if that includes to dismiss the eviction case. The landlord can't ignore or deny the request simply because of the type of the animal or the size of the animal, but particular regulations may apply to particular animals. Now, in this example, I don't think we gave enough detail there. So again, he's going to have to meet that standard that it's necessary and there's the nexus between the disability and the requested accommodation. But certainly if he does do so, then the landlord would have to grant that accommodation, even though they are where they are in the eviction case. All right.
Helen has a disability that makes it difficult for her to walk and requires her to carry bulky metal equipment in and out of her car when she comes or leaves home. She has been using an informal spot that no longer is available because of construction. All of the assigned spots close to the building are taken, and she requests an accommodation that she be given one of the 2 spots on the ends of the parking area that have extra space that she needs to move her equipment. The landlord asks the tenants with those spots to give up their spot in exchange for a reduction in rent, but they refuse. What must the landlord do?
All right. So once again, the landlord has to consider the request and engage in that process and do so in a timely and good faith way. Unless the current tenants with the requested spots also have a disability-related need, the landlord may have to require one of those tenants to give up their spot. And again, in the hypo, the landlord offered this at the beginning, but it's important to note that the landlord may be required to reduce the rent of a tenant that has to lose their spot if that constitutes a reduction in services under the rent control law. And that's something someone could contact rent control to learn more about.
Jean has a disability, making her highly sensitive to dust and dirt. She writes to her landlord saying that she cannot breathe well and is constantly coughing because of the carpet and needs to have the old carpet replaced with some kind of solid flooring. She does not use the words reasonable accommodation or reasonable modification in her request and does not offer to pay. Is this a reasonable accommodation or a reasonable modification? What must the landlord do, and what should Jean do?
So this one is a little bit complicated. So for the first question, is it a reasonable accommodation or a reasonable modification? Sometimes the line isn't as 100% clear. So for example, here, it may depend on what the situation with the flooring is. So if there's a finished floor underneath the carpet, probably a reasonable accommodation. That means that the landlord would simply be required to kind of remove that one layer, possibly clean a little bit, and then there would already be that solid floor there. So, that's not a structural change at that point. But if removal and replacement would require installation of a finished floor, that's probably a reasonable modification. That would constitute a structural change. So in terms of what the landlord must do, again, I'll just reiterate, engage in that interactive process in good faith, dialogue with the tenant. It doesn't matter that the tenant didn't use those words, reasonable accommodation or modification. There aren't magic words with respect to these protections and laws. The landlord has to protect her privacy. If they are told about, for example, what the condition is that is causing her breathing issues, not disclose that. If it's a reasonable accommodation, then the landlord would need to cover the cost of removing the carpet. If it's a modification that would require that installation of a new finished floor, then the landlord should work in good faith with the tenant to approve what the work would be, which would then be paid for by the tenant. And so what should Jing do? If she'll need to cover the cost if it's a modification, and may want to seek legal or financial assistance, such as that DCRC program that I talked about a little bit ago. And so that is the end of our presentation.
Thank you, Jonathan and Autumn. So now we have time for questions and answers. If I could get all of our panelists to turn your cameras on. There we go. So thanks everyone for your questions. I think this first one is for Gary. Have the number of legal actions been reduced? The workshops have been put on by the city. If not, would it help to require property owners to receive a brief training before receiving Section 8 payments? You're muted, Gary.
So that's a really good question. There's been a couple of different studies on how workshops have an impact, and they say that once someone learns the fair housing rules and laws, especially the reasons behind them, they are much less likely to violate those laws. So while we can't put a number on that impact here in Santa Monica with the workshops that we've had, we know from studies of the past that it does make an impact. At the same time, our workshops are open to both housing providers and tenants, and the tenants are learning what their fair housing rights are at the same time that the providers are learning their obligations. And so that can tend to increase reporting of violations. So we have a mix going on in Santa Monica, but I don't think we can put a statistical number on that impact.
Thanks, Gary. Our next question is for Jonathan. What programs can I take advantage of to prevent me from using most of my income to pay rent?
So I think a good place to start would be with the Santa Monica Housing Office. And so you can Google Santa Monica Housing or Santa Monica Housing Office, and that will come up. They would be able to provide information um, um, both about Section 8, but also the below market waitlist and other programs that may be available. And you can also leave a message at the number, which would be 310-458-8740.
Thanks, Jonathan. This is a question about a reasonable modification. I think Autumn or Jonathan can take this up. If a prospective tenant has had brain surgery and may now need railings in the unit, can that be accommodated?
So that is the kind of situation that could be I think it may be a reasonable modification. There may be circumstances in which it could be an accommodation as well. Again, that depends on whether or not it's a structural change, but certainly that is something that they could be legally entitled to. And the question may be whether or not they would need to cover the cost of that.
Excellent, thanks. This is a question, I believe it pertains to the Section 8 program, but I'm not quite sure. Does the property owner have to provide a reason to the applicant as why they were not selected? E.g., if the owner has a better fit applicant. I guess that could apply to any situation. I don't know if one of our attorneys wants to take that up. Gary Rhodes.
Well, I'll give it a shot. Well, I think in the vast majority of cases, you don't get the reason, especially in a competitive market where there's lots of people applying. You may not get the reason. You may not even get a notification that you're not getting the unit. What happens with fair housing cases is that often the person who applied got some sort of signal about what the issue may have been, when they met with the person or talked to the person over the phone. And sometimes it's just a like a bad vibe, like that happens as soon as, traditionally in the race discrimination cases, persons of different races would get certain either facial expressions or really poor treatment that sort of this grudging sales tactic that defied the logic of anyone that really wants to rent their apartment, the most deserving tenant. And in those cases, you would have to follow up, without any direct evidence of discrimination. You would follow up with testing. I think someone earlier this evening, it may have been Etta, has mentioned testing, where testers follow each other, and if one tester is treated differently, told different things than the other one, then that can be evidence of discrimination. And testing definitely happens in Santa Monica and in LA on a regular basis.
Thanks, Gary. And the next question is about the Preserve Our Diversity program. What more can the city do to promote the Preserve Our Diversity program? We have qualified tenants who refuse due to fear and misunderstanding. Etta, that would be great. Thank you. You're unmuted, Etta, you should be. Or not.
Apologies. I'm so sorry. It took me a while. And what can we do? I mean, this is again where we outreach is so critical and correct information is critical. The housing office, the city's housing office does administer the program. So it is something that we can certainly refer people to the right location. We can also work with them and coordinate our information and make sure we get the right information to the right place. If there is someone that is interested or is someone else knows about them, they can certainly call us and we could make the referral. But I do think this is again where outreach and an informed community is a healthy community, and certainly the city is very interested in reaching out to the senior vulnerable community. So we need to keep our lines open. Thank you.
Thanks, Etta. And another question about reasonable modifications. Age is not a disability, but as we age, grab bars by the toilet and the shower are often a necessity. Are they reasonable accommodations or modifications? Or Jonathan, you want to take that up?
So certainly just because a disability, might be caused by age or things that happen when we age, doesn't mean that you're not entitled to the same rights as long as it's impairing your life and meets that definition of a disability. There may be, I'm hesitant to give a firm answer with respect to the specifics of grab bars because it's possible that there is specific law on that I haven't looked into very recently. But again, I'm confident that that is certainly either an accommodation or a modification, and that if you meet that standard, if it's necessary to have equal access to the place because of a physical disability, even if that has been caused by aging, then certainly you would be entitled to that and you could request it and go through that process that we went over.
And I just want to add that Jonathan mentioned earlier the Disability Community Resource Center. They get funding actually from the city to make modifications happen, modifications such as grab bars and wheelchair ramps, things that the tenant or the landlord can't, especially if they can't afford them. Not only does it come with that funding, but they go out to the property with experts to see how it should be done, in a professional and workmanlike manner, and they have the vendors on hand to make sure that happens in the execution of the project. So I just wanted to, remind folks that this is a great resource for tenants with disabilities in Santa Monica.
Very. And any landlord or tenant who has questions about modifications or accommodations or any other fair housing issue, please do call the city attorney's office, and I'll provide the phone number. It's 310-458-8336. And you can give us a call, and we're happy to talk over specific situations having to do with any kind of fair housing issue. That's the end of our questions and the end of our presentation tonight. I want to thank everyone again for joining us. We look forward to this event every year. We hope to do it in person again sometime soon, but we're glad that we're able to have this this time to get together with the community on video. And I just want to thank again the presenters, the panelists, and also my colleagues Bridget and Johanna for putting on this workshop. It's been great, and we look forward to seeing you again next year. Thank you so much. Good night.